Defendant's advisory to the court. Come now, defendants in the above styled and numbered cause, and without waiving personal jurisdiction, but rather insisting on the same, and make this their special appearance in order to file their advisory to the court regarding plaintiff's response to defendants' attempt to confer in connection with defendants' motion to seal exhibits to defendant PACT's motion for summary judgment, and state as follows. I.
My name is David Griffin, and I'm going to be responding to a defendant's advisory to the court. I've sued public access television for age discrimination, and now it's turned into more of a freedom of speech and how lawyers basically just don't know how to tell the truth. But what we're going to do is listen to each paragraph, and I'm going to respond to them. Listen, learn, and let's see what's going on. Paragraph 1.
On May 20, 2009, defendants filed its motion to seal exhibits to defendant PACT's motion for summary judgment, document number 32. Defendants attempted to confer with plaintiff regarding their motion. As exhibit A is a copy of the email from counsel for defendant to plaintiff and plaintiff's reply. Defendants attach a copy of the email so that the COL can evaluate the extent of plaintiff's agreement. Defendants' counsel wishes not to be accused of misinterpreting the plaintiff.
Boy, that would be a first, not to be misconstrued. Let's just see what happens.
SDHC Court can see in plaintiff's email reply. He states, I have no problem with redacting social security numbers and salaries, but I will object to any other documents being sealed or destroyed in light of plaintiff's limited agreement. Attached and marked as Exhibit B are copies of the exhibits to the motion with the social security numbers and salary information read.
And like I said, I don't have a problem with personal information not being shown. All the employees of PACT are not involved, and for whatever reason, John Heller decided to file paperwork that basically puts every employee at risk for identity fraud. From the beginning, I've always contested that I've not followed the proper procedure, and I've simply been trying to get this case dismissed from the beginning. Why these papers were filed in the first place, I don't know. They were not necessary. They were not in dispute, and from the beginning, I've been trying to get it dismissed. John Heller has spent thousands of dollars of public access money defending this. Why, I have no idea. And the fact that he discontinues go on. Let's read the next paragraph.
The original documents were produced to serve as evidence of the number of employees of PACT. Plaintiff has judicially admitted that this is not a contested point and the exhibits are no longer necessary. Therefore, the best way to ensure the most protection is to remove the documents altogether rather than merely substitute redacted copies. Plaintiff has not put forth any reason why the documents could not be removed and DSH.OID. Defendants continue to remove the COUID to remove, unseal, or destroy the exhibits in the court's file as set forth in its motion for the reasons set forth therein. However, defendants submit attached Exhibit B to facilitate the removal of the sensitive information at the court's earliest convenience. Should the court deny defendants' motion to seal or destroy the documents, the exhibits are available in redact CD form for substitution with the agreement of plaintiff.
Now this statement is just not true. I object to having any documents sealed because John Heller has filed false and misleading documents in the past. I explained in my email response that until the accuracy and the validity of these documents they're wishing to seal or destroy are verified, and only can be done through discovery, but I agreed that they're no longer necessary. Due to the fact that they do file false and misleading documents, have filed false and misleading documents. Only reason why John Heller would like to destroy these documents is to hide something. I made this quite clear, so this is an inaccurate statement.
Defendants continue to U1 get ECO on their motions to order plaintiff to review L11 documents and refrain from any dissemination of said information. Defendants believe that this is imperative because of plaintiff's expressed belief that he has a constitutional right of freedom of speech, and therefore is likely to attempt to disseminate such information unnecessarily.
Yes, I do have the constitutional right of free speech. All the documents in question right now are public record. This is a trial in a federal court. Everything introduced in federal court is considered public record. I do believe in freedom of speech. If the court would read the name of the complaint, it would say public access community television. The whole purpose is for free speech. So why would they assume I would not be an advocate for free speech? I've also been a journalist for 29 years, working for CBS, ABC, and all the major news outlets. I've been recognized by my peers with the Emmy for my work in Vietnam in 1985 with CBS. I've also been all over the world and done many things. I would have to prove this since the court doesn't take anything without evidence or proof. So I would submit my resume and ID cards from the networks to show that I am a journalist. And yes, I do believe in free speech. Obviously, John Heller doesn't believe in the Constitution or free speech, and only guilty people hide these documents. So if public access did nothing wrong, then why would they go to such extents to hire two law firms, one in San Antonio, one here in Austin, to fight and to uproot? Why do they hire two law firms? These firms are costing public access thousands of dollars for this legal activity. Where is public access getting this money? They're getting it from you, the citizens of Austin. City of Austin has a contract with public access. To my knowledge, the only contract this nonprofit has. So all the funding, everything comes from the City of Austin. So even though the purpose of public access television is to promote free speech, as long as the free speech is not against them, that's the problem. If you're not on board with them, then no, you don't have free speech. As long as they agree with what you're saying, then it's free speech. But the minute it isn't, then it isn't free speech. It's the way it works here in Austin, Texas.
As the court can witness from documents filed with the court and FDOM plaintiff's recent email, plaintiff repeatedly uses the words slander or slanderous in connection with statements either by defendants or by counsel for defendants. It is obvious that plaintiff is using those terms in a colloquial, rather than a legal sense. As set forth in plaintiff's email, plaintiff states to counsel for defendants, there is still the matter of you filing false and slanders, sick testimony. As you know, I have filed a complaint with the Texas Bar Association, the BBB, Better Business Bureau, Travis and Bissar County District Attorneys on your misconduct, in a letter that plaintiff sent to the Texas Bar Association, the BBB, Better Business Bureau, Travis and Bissar County District Attorneys, and to multiple of undersigned counsel's partners. Plaintiff accuses counsel of criminal and libelous activity.